All right, everyone. I think we're going to try to get started. I don't know how many people who have done these Zoom calls. I imagine a lot of people have recently started doing them, but this is actually a webinar. This is not a meeting. Some people have done a lot of Zoom meetings, but I guess the nice thing about this is we don't have to mute everybody, and we have a feature where you can pose questions. If somebody wants to speak and they have an interesting question that wouldn't be good in a post, you can ask me to unmute you or add you as a panelist, because I'd like to get feedback from everyone who's attending. So it's just a little after 12:05. We're going to try to get started. A lot of people have joined in. I think a few more are on their way. I decided to do this webinar because I thought it was important to get the information out. There's a lot of things that have been changing. Last Wednesday, I was on a panel of a couple attorneys, which included our county clerk, and we gave a webinar to about 60 or 70 lawyers on how to get by in the COVID-19 era doing real estate. Most of you who I saw signed up, I know I've worked with, but I've been doing this for about 25 years. This is all new stuff. I've been a long-time member of the Bar Association. I was the chair of their real estate section. And so when this first came out, we realized as an organization that there were going to be problems, and we were going to need the help of the governor and the state in order to move through this. So one of the first things that I was involved in is I helped draft a letter, which our Bar Association ended up sending to the governor. And we asked for three things. And this was before any of the executive orders came out that addressed anything related to real estate. So what we asked for is we said, the first thing that's going to be a problem is doing closings, getting smoke detectors, getting COs. So we asked for some guidance on a statewide basis. One of the problems in New Jersey is we have 565 municipalities, which is crazy. So every town has their own rules and regulations. As most of you know, every single one of those has to have a smoke detector as a requirement of closing. And about half of them choose, which is elective, to do a certificate of occupancy. So I've been doing this a long time. I've practiced in many towns throughout the state, and I remembered there's a few towns in North Jersey, specifically Hoboken, Jersey City, which have never required a physical inspection to get the smoke cert. They simply ask that the owner and buyer sign an affidavit that they have working smoke detectors, carbon monoxide detectors, and fire extinguishers at the property. So we asked for the governor to direct the entire state to operate on that basis, so that we wouldn't have to put the inspectors at risk going into homes or towns that have closed, and it wouldn't interrupt our ability to do closings. That didn't happen in a mandatory way, but there was a letter issued shortly thereafter by the Department of Community Affairs, and they did instruct the towns to follow that pattern, to no longer go into homes. In fact, the DCA, who conducts all the state inspections, they officially changed their policy and said, we will not be going into homes. We will not be going into buildings. We will, in turn, we're going to pivot and we're going to use this other method of affidavit. And so that's what they suggested that the towns do, but it wasn't a mandatory thing. So as a practical matter, when we're doing closings, we still have to check with each individual town to see what their particular policy is. The second thing we asked before I get to that, I thought that was about smoke detectors, but with COs, it's more complicated. And the state has not offered any direct guidance on COs. So you still got to go and check with the municipality. Some of them are operating and going into homes, provided the home is vacant. Others are allowing a homeowner or an agent to use a audio-visual platform like Skype or FaceTime in order to see what's in the home, and then they'll base their issuance of a CO on that. So again, unfortunately, that is a town-by-town basis today, and there was no mandate or executive order that dictated what each town had to do. The second thing we asked for in the letter from the state bar to the governor was that they keep the county clerk's offices open. Now, we're fortunate in Monmouth County, and I mentioned I was on a call last week with our county clerk. They've done a great job staying open, albeit on a skeleton crew, and even allowing searchers to come into the building, provided that they know they're searchers, and they're alternating days. So they have the workers who work for the county there, I think right now on Monday, Wednesday, and Friday, and they're allowing the searchers to come in on Tuesdays and Thursdays. And the good news is that means we can still do closings. You know, most people have gone to an electronic recording platform, an electronic searching platform. Monmouth certainly is one of those. And so we've been able to, without any direct mandate from the state, at least in our area, be able to still do closings. Now, there are other counties. Mercer closed down about 2 weeks ago now. Fortunately, they did open up last week. So they're back up and running, not as maybe fully operational as Monmouth and some other counties. And I think Camden closed completely, but there is a daily list, which I check to see who's open and running. So we really we need to be able to record deeds. We need to be able to record mortgages. We have to do searches to see if there's clear title. And then the final thing we asked, the three things we asked, the last one was that the municipal tax offices stay open. And again, could be one person there collecting the checks, posting online, because we can't do closings if we don't know if the taxes are paid. So for the most part, that has worked. Again, no direct mandate from the governor on what has to be done, but as a practical matter, we're doing closings. You know, I did a closing yesterday, I have a closing tomorrow, and I'm gonna get to how we're doing closings a little bit later. So we did that on a state bar level. We have, you know, lobbyists that are trying to push these issues to make sure we can all do what we need to do. And as you know, the governor has issued a series of executive orders. So I think it's important that we review about 3 or 4 of them which relate to what we do. The first one was Executive Order 107. And that was the one that basically said, everybody, that was on March 21st, everyone needs to stay home, retail places need to close, and if you are another type of business, you have to do your best to telework as possible. And then they mentioned that construction workers, repairmen, people like that who had to be on site could still work. It was a little bit vague on whether real estate agents can continue to show homes. And fortunately, that order was clarified, I think the following week, to say that realtors may continue to show homes, but it has to be on a one-on-one basis. They can't hold open houses, and they have to be practical and considerate and thoughtful about how this is going to happen so everyone stays safe. And then the next order that came out was Executive Order 108. And that said that no municipality can impinge on or enlarge or restrict the executive order. So if the governor says that these can be open, the town can't say, no, they can't. And if the governor says this cannot be open, the town can't say, oh, yeah, you can. And that was an important order because there are some things in there that relate to what we do. And we can use this to convince certain municipalities that, look, they can't change that. If the governor says we can do this, you have to make sure your laws comply with these orders. So as attorneys, and I'm on a local council here in Manaloking, so I've been involved on a day-to-day basis in interpreting these orders and making sure that we are, as a town, and the other 565 municipalities are doing the same thing, enforcing the proper ordinances and making the proper orders that comply with the executive orders. So after these were done, around the same time, the New Jersey realtors, you know, Barry Goodman, who I've worked with for many years, put together some addendums to your standard realtor contract. And those are important to first understand what they mean and to use them when necessary. Obviously, I would defer to your broker to determine if and when you should use the forms, if you're going to make additional modifications. but I do want to go over a few of them because I think that they have a good place and they serve a good purpose. So the first one, which was issued on March 20th, is a standard. It's called the Coronavirus Addendum. And I got this on one of my deals and I read it, and I didn't like it at all for the particular deal I had. Basically, what it says is it addresses the idea that things could get delayed. And I suppose the goal is to try to hold these deals together and be reasonable about any delays that occur. The thing I didn't like about it was there's another paragraph, paragraph 2. If you check this off, this says very broad and obviously favors buyers. So that for any reason, the buyer can't close because their income has been reduced as a result of the COVID cancellations or anything related to that, then the buyer can cancel. Well, that doesn't really jibe with what we understand in a normal contract. I mean, a contract has a mortgage contingency, and there are provisions in there. Typically, we adjust those in attorney review that says if the lender is no longer willing to make the loan or the loan is denied because of an income change, then you could cancel. This particular addendum that was prepared, that's a New Jersey Realtor form, goes even further than that. It says if this is a cash deal and there's no mortgage contingency at all, then if the buyer decides they're making less money, they can just cancel. So in the particular deal I got, this addendum was included. It was a cash deal where the borrower had to show, or the buyer had to show, sufficient funds. We reviewed the funds. We were closing in a few weeks, and they had this addendum on there. So I guess the point is, these are new. Read them. Try to understand whether they're helpful to your particular closing, and add them as needed. There's another big blank clause that says number 3, where you may want to add specific changes that are related to the coronavirus. Or, no one's suggesting that you have to be the attorney here. Call the attorney that's involved. I mean, we're open. We're doing business every day. Not in the office every day. We're kind of staggering. My staff is there some days. I'm there some days. But no matter what, if you call our main number, 747-8300, we will answer, and we're working really hard as ever. It's a little slower with new deals coming in and closings because we'll get to how that has to happen. But we're here and we're trying to understand and learn what we need to do to get through this. All right, so the next form that was put forth by the New Jersey Realtors was a hold harmless form. And this is probably the most important, obviously, from a liability perspective. It's a pretty in-depth form, and it's got a lot of pretty serious requirements. So let's just run through them quickly. And there's 2 different forms, by the way. There is one for homeowners who are selling their homes, and then there was another one just released last week, which is very similar, but it's for tenants and landlords. So this is a form that you want to get signed even before you get to contract stage. This is just for showings. And again, I defer to your brokers, but if I was the broker, I would certainly want this form signed because it protects you as an agent, it protects the buyers, the sellers, and it protects you from liability. I mean, if you're getting sued, somebody goes in on one of these listings and an owner or somebody gets sick with coronavirus, they may say that you didn't use proper precautions and somehow led to their illness. So the form says, let's start with the one for the people who are showing homes, that there's an agreement that each buyer would have to sign that says only that buyer and their immediate family members, the inspector, and the real estate agent can enter the home. That's number 1. There's another section that says they acknowledge the risks of COVID-19 and they waive these risks. And then, and this is the trickiest clause, and look at it carefully and make sure if you have your parties and clients sign this, and when you sign, actually there's not a place for realtors to sign, that you've read through and they understand it. Here's what they're asking people to represent. Number 1, that you have not tested positive for COVID-19. Number 2, that you're not showing any signs of COVID-19. And by the way, I should start off saying it's not just the people who sign it, but they're representing that this is true for themselves and any member of their household and their agent and inspector. Again, number one, they haven't tested positive. They haven't shown any signs of COVID-19. They haven't been in contact with anyone in 14 days who tested positive or is waiting for results. I mean, this is very broad. D, they haven't been in contact with anyone who's traveled abroad in the past 14 days. And then it says you must continually update this information if anything changes by notifying the other parties. And then, of course, the most important one is at the very last clause. It says you will hold harmless the broker and indemnify them, and no one's going to sue you for going through this process. So it's important, it's protective. I imagine your brokers want you to use this, but remember the time to use it is before you even show the house, because that's the critical stage. Same holds true when we get to the lease part. The leases, same language, except they don't mention inspectors. Obviously, you don't typically have an inspection on a lease. They don't mention appraisers because I guess you don't know who your appraiser is, but we'll get to that. They may need to get in the home as well. And then the final form that was put out by New Jersey Realtors was the seasonal lease form. So this one I think is important because in our area, Monmouth County, Ocean County, we do a lot of work with summer rentals. And this particular form talks about what if situation changes and people are required to, or the language they actually use says that if the lease becomes frustrated, impossible, or impractical due to a government or business shutdown. The beaches are shut down right now. All state parks are shut down. So does that make it impossible? I don't know about that, but maybe it makes it impractical or frustrates the purpose of going to rent a beach house if you can't use the beach. And so it goes on to say that if this is the case, either the tenant or the landlord can decide to cancel the contract as long as they give the notice 30 days before the lease is supposed to start. So again, and maybe that date needs to be modified. Maybe 30 days is appropriate, or maybe it's 60 days, or maybe it's shorter time, depending on when the lease is signed and depending on what the parties want to agree to. So more complicated issues that come up now because of this coronavirus, you do have the tools on some level to deal with them. So make sure you're aware of these resources. By the way, NJ Realtors does have a nice site where right when you go to the site, you can click on COVID-19, and they have a lot of great information on there. So avail yourselves of that resource. Most of the people on this call are licensed realtors. Go to the site. It's in plain language. They do a nice job. The other place you can find the new stuff is if you Google New Jersey Governor Executive Orders. There'll be a page of every governor. You click on Phil Murphy, and then there's his 120 some orders. Don't worry about the first 100, but after that, it's starting with like 103 on. They're all related to COVID. So if you're interested, or someone has a question or an issue comes up, I'm going to refer. I already referred to some of them, and there's one more we're going to refer to in depth that deals with construction. And if you want to go look at those documents, just take a look at that page. All right, so where does that leave us? Let's try to think and talk through how we would do a normal closing from beginning to end. So as we mentioned, the first thing you have to do is get those hold harmless agreements signed, assuming that's what your broker wants you to do. And have your each buyer that you take sign it, each seller that you're going to their home, have them sign it. That protects you. And then be respectful. If the seller is currently living in the house, ask that they vacate and have no one in the house. Don't bring a whole crowd of people with you. Like the agreement says, it'll only be the buyer, hopefully, maybe their immediate family, maybe the kids don't need to come. Try to limit those numbers. Wear masks, wear gloves, get an agreement with the seller of how you will conduct yourselves. Ask or do this yourself before they come in. Maybe the seller can turn all the lights on, get everything working, so no one has to physically touch anything in the home all the light switches and everything. I mean, hopefully you're wearing gloves anyway, but still, if everything's on and ready to go, these are just some of the things you could think through before showing in this environment that we're in. So you've shown the house, maybe it's time to get a contract and we move forward, get into attorney review. Like I said, most, we're open and running. Most lawyers are working remotely and still doing our thing. Appraisals is usually the next touch, or actually, let's talk about home inspections. That's probably next. There's a lot of home inspectors out there. There were a few that said they weren't going to do inspections. More commonly, I see inspectors are willing to do inspections, but they want the house vacant. And again, I think you probably want to have some kind of an agreement or arrangement with the home inspector that they'll be respectful, that they'll wear the gloves, that they'll wear a mask if requested by the homeowner, and it's just them in the house. I mean, maybe the agent's with them if the homeowner wishes, but honestly, unless it's required, I would let the inspector go and do their thing. They're licensed professionals. And get the report and move on. Appraisals. Some appraisal companies are shifting to what we call drive-by appraisals. They're no longer going into the homes. That's not true across the board. Some appraisers still need to go into homes. That could be a lender requirement. It could be because of a high value loan that they're giving, but be prepared that you may get a request for an appraiser to go into the home, and sellers need to be aware of this and they need to cooperate or the loan's not going to be able to go through. Same process as if you're doing the inspections. Make sure the house is vacant. Appraisals don't take very long. If someone's living there, let them go take a drive with their family. Make sure the appraiser wears gloves and a mask and is respectful. If the appraiser needs anything to be operating and running, get that operating and running before the appraiser goes in so they don't have to, they can run right in and out. All right, and the next touch, and this is obviously the trickiest stuff and it's important, is we get to the government interactions with the deal. And as I mentioned before, the first thing we worry about are the smoke detectors. And the DCA guidance, March 21st was issued. This is what it says in the guidance. We strongly recommend the agency suspend further inspections and utilize the affidavit approach outlined until the executive order expires. So while it's not mandatory, it was strong recommendation from the DCA. And I would be surprised if there's towns out there that are just stonewalling and not allowing closings to take place, because closings are essential, and that's already been cited in the executive order, the confirmation of 107. So often we need to get involved as attorneys when we get any pushback from the town, and I encourage you to consult with the attorney that you're working with on the deal or call us, and we can often call and speak to the representatives at the municipal level and remind them of this guidance and that they can't prohibit a closing. They can't stop a closing. I mean, first of all, municipalities only have the right to regulate based on their police powers for the health, safety, and welfare. They can never control when a closing takes place. They can, however, control occupancy, because that does relate to health, safety, and welfare. But they have to be reasonable under these circumstances. They have to follow the executive orders, and they really should follow the guidance of the state DCA. COs, again, they're trickier. We have been working with towns to get things done. Most towns are cooperating. Some towns, they're not there every day and they're not doing inspections. There was actually specific guidance, not on COs, but on COs that relate to construction projects. So there was an order just the other day, which I'm going to go over in a minute, that specifically deals with what construction projects can go on. But there was guidance from the Department of Community Affairs on how to deal with ongoing construction projects, because there's a lot of touches in an ongoing construction project with the municipal offices, the building department. They're not just doing one inspection, they're doing sometimes 5 or even more, 10 inspections to issue the electric, the plumbing, and at each stage of construction, certain inspections. So the DCA offered guidance to all the local municipalities, and they said the following, that number one, continue to do inspections if you can, Anything exterior you should do. If it's a construction project, just make sure the place is vacant at the time and do what you need to do. However, if your town has closed, you might be able to do things remotely using Skype, using FaceTime. And if that doesn't work, they give direct guidance to the construction workers and the tradesmen and say, look, do what you need to do, document it, take photos, take video, and when the offices open up, they must go back and inspect at that time. They specifically said construction projects can continue. So for those that can continue, we're going to talk about which ones can in a minute, but for those that can continue, the town can't stop or stand in the way of the executive order that says the construction project must go forward. And they really need to follow the guidance of the Department of Community Affairs that says that they need to make changes, they need to allow for alternative ways of inspecting if they're not physically able to do that. And most importantly, that they can let the contractors who are licensed professionals do what they need to do, certify what they need to do, take pictures and video. And it also specifically says the town can't come in later and make you rip the walls out, or even if they're a little bit concerned or you didn't get a good picture or something, they can't do that unless there is reason to believe that there's a life safety violation. So they're really being aggressive to make sure that these projects can continue, because it's a large part of our economy, and even larger part of our economy is shut down. So the parts that they are permitting to be open, they're going to be aggressive about allowing those to happen, and we should too. There's a lot of projects that we're involved in as lawyers, as realtors, that are ongoing construction. And when we hear about these problems, make sure we direct our contractors and buyers and sellers to consult with their lawyers to make sure that things are moving forward at the proper pace. All right, so Executive Order 122 was just put out, it was like on Friday, I think, last week. And it addresses construction projects. So it basically said construction projects have to stop, except for, but there's a really long list of the except fors. If it's affordable housing, if it's government housing, if it's hospital, all that kind of stuff. But the stuff that we really care about in the work that we're doing here is the single family homes. And there's two specific categories, and this is where you may want to take a look at Executive Order 122. So specifically paragraph 2F, that addresses projects that are already underway for individual single family homes or apartment where an individual already resides. Now, there's been a lot of debate about what that means. Does that mean they're actually living there and the contractors come in and work while they're still there? Or does it mean a house that's already been lived in and they're not in the house now because an addition is going on or whatever reason? So it's a little bit tricky. But if this is going on where there's a project underway where, quote, someone already resides there, that can continue. That's a big group of homes. And the only limitation is that it must continue with the construction crew of 5 or less workers. So fine, that's 2F. Then they have 2G. Now, why they had to make a different one, I'm not quite sure, but they say projects that are underway for residential where either a tenant or a buyer has a contract to occupy by a certain date. This is where we come in, I think, on a lot of ones where we're waiting for construction to be complete or new tenants going in. Those can continue. And in that particular paragraph, they don't even put the 5-person limit. I've received guidance from municipal attorneys that say in that situation, you can have up to 10 because that's the boilerplate rule, no more than 10 workers. But different municipalities are interpreting these clauses very differently. And you really have to just battle it out with each town because they're the sovereign right now. There's probably not time to go into court and deal with this with the judge. You really got to win your battle at a municipal level for these items. And you got to know the law, and you got to know what other towns are doing, and what the weight of authority is. We have gone back often to the governor's office, to the drafters, to find out what the intention of the order was. They're not always written great. I mean, sometimes there's problems. They're doing it on a very expedited basis. So to that extent, I understand, but it would have been nice if there was a little bit more clarity on F and G in the executive order. But the one thing that I think folks are clear on is that there can be no new projects. They continually refer to projects already underway. So that's a problem if you have if you're a builder, if you have a client who wants to buy new construction. Until there's a change in the executive order, you can't go get a permit to build a new house. Now, they may allow you to do the preliminary work, the surveying, anything leading up to issuance of the work permit. But as of today, you cannot do that. So 122, take a look at that. County clerk's offices, we talked about briefly. Like I said, good news is we're still able to do what we need to do. Municipal tax offices also, so far, so good. All right, so let's talk about closings. We've been doing closings. It's great when you have a cash closing. I mean, when you have a cash buyer, we're always happier. It's easy. They wire us the money and we do the closing. So those have been relatively seamless. And they're just sliding right along. With, of course, the caveat that we have to get the CO, we have to get the smoke detector, but for the most part, the cash closings have been a breeze under the circumstances. Mortgage closings, on the other hand, are difficult. They're very tricky. And the ones that we've done, I did one yesterday, which was a refi, and I think the lenders are being more liberal. Historically, if you're doing a closing or a refi, the lender requires that the borrowers be present. And the only exception to that is they often will allow, if there's a married couple, they will allow one spouse or one borrower to sign for the other one with a proper power of attorney. Some lenders have been more liberal over the years, and they'll let you appoint a relative or a friend to do that, but it's rare. So we did one yesterday where they let my paralegal be the power of attorney for both borrowers, and I just notarized everything, and that's how we did that closing. The other day we did one where we had to physically have both borrowers in the room, so they walked into my office. We had all the documents set up on the conference table in advance. They sat down, signed everything. It was all marked out where they needed to sign. They left, and we came into the room. We notarized stuff and sent it out, washed our hands, and we finished the closing. So it's possible to do it. We have to keep all social distancing practices in place and be aware of the fact that we're doing this on a very rigid basis. This is not business as usual. It only happens when it has to happen that way. So on to when it has to happen. We have been, as a state bar association for many years, trying to shift from the paper closing to the virtual closing. And we, many years ago, they passed the Electronic Recording Act, but that really hasn't helped much because lenders are still requiring that the borrowers be present. So there may be a shift that's going to come out of this pandemic. And there's actually a bill, which was a modification of one of the bills that had been already pending in New Jersey. And this was an emergent bill. We made certain recommendations as a state bar. The original draft of this bill only allowed notaries to do remote notarization. And as most of you know, in New Jersey, attorneys can also take a notary. So we wanted to make sure they amended it to add lawyers in there, which they did. The original version also did not allow wills to be notarized this way. The estate planning bar was very worried that there would be fraud if wills were done this way. But they did add that you can do a will now this way with this new act. Now, the act is hot news right off the press. Yesterday, the Assembly and the Senate voted to approve this new act. If you want to look it up, it's A3903. Now it is waiting on the governor's desk for him to sign, and it's expected, of course, that he will sign. It was passed unanimously. It was 79-0 in the Senate and 38-0 in the Assembly, or actually the reverse. So what does this new bill say? So attorney or a notary can do it. You have to see 2 forms of ID, or you have to actually know the person. And you have to keep an audio-visual recording of the process you went through to authenticate and notarize with you for 10 years. So that puts a burden on the remote or electronic notary to do that, and to have a depository, is what they call it, that you designate where these audiovisual recordings will be. So that's great. Now, this particular act, it was done on an emergent basis, is only good while the state of emergency is in effect. So if we go back to normal, hopefully someday, we're going to have to revisit the language in this legislation and hopefully extend it so it will continue on beyond any restrictions of the pandemic. So that's all well and good, but what we really need to happen is we need the lenders to jump on board and say, okay, you can notarize remotely, you can record remotely, we're going to allow a closing remotely, because as of today, they still want original notes and sometimes original mortgages, and that means wet copies, so that creates a problem. There are lenders out there that are doing this. There's a few platforms that have been created to accommodate remote closings. So the lenders, what they do is they pick these services, these web services. One's called Notarize, one's called Pavana, I think, and we've signed up for them in my office so that we can conduct fully remote closings. And we hope that this is going to continue well beyond the pandemic. I mean, sometimes it takes bad situations like we're in to bring some of this legislation front and center and actually get it pushed through. We've been trying to get this, like I said, for many, many years. I mean, not 2 or 3 years, like 10 years plus. I've been doing this for 25 years, and I can remember a long time ago just hoping we can get away from the paper closing and onto the virtual closing or the electronic closing. So I think that is on the verge of happening. You might see electronic closings happening really in the next week or two if the governor signs this. And then it won't be widespread, but there'll be some lenders out there who will do this. There'll be some attorneys, title companies set up to do this, so that will actually happen. So that is, one small bit of good that could help our industry that may come out of what we're dealing with here. All right, so we talked earlier about the New Jersey Realtor addendums. And ever since this started, I've been, in my attorney review letter, adding extra clauses to address government shutdowns, business shutdowns, and obviously delays in closing. So the gist of my clause that I put in there is that we're going to all do our best to hit all the dates in the contract. But all dates, whatever they might be, are going to be reasonably extended under the circumstances. So I think that's an important provision to put in for both sides. Sometimes the sellers can't get their mover, sometimes the buyers can't get their mortgage on time. We don't want anyone to suffer contractually because of a issue with this pandemic. A lot of people have talked about time of the essence. So in New Jersey, time of the essence is governed by courts. There's no statute that says you can make time of the essence. It's developed by case law over the years. And a lot of people think, because it's appropriate in some situations, that the proper time for time of the essence is 10 days. It's not. It's just that a normal contract to closing is usually 45 to 60 days. So there have been cases that have gone before the court where a 10-day or 2-week period was given, and they've been upheld as reasonable under those circumstances. And the test in all the cases is reasonableness. There was one particular case where they illustrated this, where there was a contract to close a year later, and the year came and the people weren't ready to close, and they said, you can't give a 10-day notice. It has to be reasonably related to the circumstances and also the time period between contract and closing. So In that case, you have to give a month or so. Under these circumstances, in a state of emergency, I think you're going to have 100 excuses that a court would deem to be reasonable under the circumstances. So it's going to be difficult to enforce a time of the essence provision. People can try it. They can cancel contracts and see what happens when the courts are reopened. And but to me, it doesn't make sense. It makes sense, I think, to try to work things out with the parties, with the buyer, with the seller, and understand what their needs are. And if there truly is, a delay that's occasioned by the COVID shutdowns, let us specifically know what that is, and let's see if we can get a work around it. Versus, a buyer is just kind of economically doesn't think it's a good idea to buy. That's more of a breach. Whereas if there's an actual reason, you try to work around it. And by the way, some people may breach, and who knows what a court's going to decide that day, but it's still incumbent on a seller, if a buyer breaches, to resell the property and mitigate their damages. So the chips are going to fall where they may, and everyone's going to have to consult with their own attorneys to decide what is best for them. And then the final topic I want to cover today, and by the way, I mentioned at the beginning that there is a question and answer. I see one question up here, which we'll get to, but please look at the bottom of your tabs and feel free to jump on there and do a Q&A or a chat and let me know what you're thinking or any questions that you have. But the final one I want to talk about was landlord tenants. Governor did issue Executive Order 106, and in there he said you cannot have any residential evictions or foreclosures. So that was helpful, obviously, to people. Not so helpful to landlords, but helpful to tenants in those situations. Now, there was no specific prohibition on a commercial eviction or foreclosure. But as a practical matter, the landlord-tenant courts are closed. So, even if you want to go ahead and file your paperwork, there's no evictions that are going to take place. So I think what you have to do in the commercial setting is, and this happens often when you have even an economic downturn and commercial tenants can't pay their rent, is you want to have a dialogue between the tenant and the landlord and try to work out some type of resolution. A lot of people are familiar with the CARES Act, and that does give certain benefits to employers. There are lenders out there who are giving forbearance. Some commercial landlords are getting mortgage forbearance. So it doesn't seem genuine for them to turn around and evict the tenant because they didn't pay when they're getting a break on their mortgage. I even saw, I think, somewhere where the governor had suggested that if this was happening, that should be reported, that they shouldn't benefit from the CARES Act or other forbearance from lenders and then turn around and injure their own tenants. And there's actually, I mentioned the Act 3903 that's pending, and hopefully the governor will sign. There's another bill that passed the Assembly and Senate yesterday, which was 3901, and that has to do with a 3-month deferment of commercial rent. So if the governor signs that, that will be on the books in New Jersey as well to address those issues. So there's a couple questions here I'll try to run through. First question was, what about landscaping projects? Okay to continue? That's not a construction project, so it wasn't specifically addressed. I think you're okay with landscaping because you're outside, you're abiding by social distancing. I don't know who's going to stop you from doing that. I've seen people getting their grass cut, and I don't think that impacts, but I haven't seen a specific executive order that addresses that. Second question I have here is, if the seller is not willing to show the home, should the listing be removed from MLS? That's really up to your broker and you and the seller to decide as a marketing strategy. Obviously, it should be stated in there, no physical showings, at least in the agent notes, I would think. But I've had clients, I don't know what everyone else's experiences have been, but I had a couple clients over the past year or two that bought houses even north of $1 million without ever seeing them. Maybe they're millennials, but there's a group of folks out there, and I think we have to be creative right now maybe someone would say, look, I like this house. I like the pictures. Drive by it, but I'm not going in. I'll send my inspector in if they're allowed to go in, and we'll see what the report says. I'm not suggesting that's the best way to handle it, but it is one way to handle it. Next question we have here is there a conflict that exists as to what HIPAA says you can and cannot ask someone versus the hold harmless? That's a good question, but that's a question for Barry Goodman, because he drafted that, and I really don't know the answer to that. But I think in a state of emergency, they may bend some of those rules, because no one's being asked and forced to do this. This is only because they're asking to go into someone's private home. So there might be an exception in that circumstance. You couldn't require someone to maybe answer that if you're, as a condition for, I wouldn't say employment, but I think under the circumstances, these kind of things, they might be a little bit more liberal on. Are there any rules around weekly summer rentals? Good question. So certain municipalities have banned short-term rentals right now. And I know you can't do them in certain towns right now for April and until the orders have been lifted. So that is a risk, and I would check with the local municipality as to whether or not there isn't been any ordinance passed prohibiting summer rentals. Any problem with having contractors going in to do repairs on home inspection? They specifically list contractors, individual repairmen, to be able to do repairs. That was not addressed in the second order about construction. I think that's different than a construction project. If there's a repair that needs to be done and there's a single contractor going in, my understanding is that you can continue to do that. But yeah, as a practical matter, there's a problem. Some contractors don't want to go out and do those. Next question I have here is, should anything be added to the seller's disclosure in light of the buyer possibly not viewing the house in person? Not a bad idea. I mean, I think for the most part, most buyers have been. You certainly would want to make sure, as you do in all cases, that the seller's disclosure is accurate. But maybe the lawyer, if there was a situation where the buyer wasn't going in, you might want to, as the attorney, add that language in your attorney review, that the buyer has chosen not to enter the home. And I suppose if a seller didn't let you come in the home, maybe there's a risk, but no one's going to buy a house without doing a home inspection. And as long as the seller's disclosure is accurate, I don't know that there's any special language, but again, if I knew for certain that the buyer wasn't going in, as an attorney for the seller, I might add some language in there that says, that they're relying on their inspector, and just make sure your disclosure is accurate. All right, let's see where we are. We're almost up to 1 o'clock. I figured this would last close to an hour, and I think I've covered most of the topics that we wanted to cover here today. I'm going to be doing some more webinars. This particular one, obviously, I just put together. And if you want to send an email to me with a question about any of the stuff we talked about today, my email is pretty simple. It's brad@batchalaw.com. So, or just give us a call, 747-8300. But we're available. Oh, I see a few more questions, so let's keep this going for a few more minutes. Let's see what we got here. If a short-term tenant that took occupancy prior to the stay-at-home issue that has a lease end in May, can they refuse to leave? Well, because there's no landlord-tenant court, they probably could, because there's not going to be anyone to evict them until those courts open back up. And I think under the circumstances, even if the courts were open, I think you'd have a good reason why you would not want to relocate. And the smart thing to do is to have a dialogue with the landlord and try to work something out. I mean, if the summer season's coming and they're getting a very discounted rate as like a winter rental, and there actually is a need for these increased summer rates, that's going to be an issue, because then you're depriving the landlord of the increased summer rental rates. So something probably needs to get worked out there, because the landlord's going to be more aggressive in trying to get some type of judicial relief to make sure that they're protected. Maybe there's a compromise where the existing winter tenant pays a little bit more for June, and then they get out by the end of June so we can get the summer tenants in for July. It's going to have to be a case-by-case basis, so it's tricky. And let's say if they have a primary residence elsewhere. You know, we talked about this, none of the orders have talked about your primary residence versus your summer residence. I know we deal with that a lot in this area. You know, the governor has gone on record asking folks who live even in North Jersey not to come to their summer home. I don't really know what to make of that. I understand from an infrastructure perspective that perhaps we don't have the police in place, we don't have the hospitals, and we don't have the infrastructure, and even the grocery stores aren't expecting at this time of year the influx of people. I live in a summer town. We definitely have a lot more folks here than we normally would have in April, especially with the weather we're having. But I understand, you know, we don't have our summer special police here. The flip side of that is there's really not a lot going on. I mean, people aren't getting pulled over, people aren't having parties. There's very limited, or there's less police interaction, I think. You know, I've talked to my friends who do municipal work, and they're at a standstill. I even talked to doctors, and they said your typical emergency room folks aren't coming in as normal. So a lot of things have changed. So that's a tricky one. I'm not sure how that gets handled, but there's been no direct prohibition from using your summer house. They just, you know, the governor said not to do that, but it's not in an executive order. Let's see what else. Biggest challenges that clients are facing. I think there's a lot of clients out there that are just, you know, they're nervous. They're wondering if they made a good deal. They think, you know, no one knows what the future holds. And honestly, that is one of the trickiest things we face in the transactional world, uncertainty. So, you know, if we all knew the market was going to do this or that, or, you know, things were going to change or rates were going to change, we could work it out and we could agree on a price. Now, this comes up a lot with these flood maps I always talk about because I do a lot of work with that. We have an unknown there. The maps are still being worked on and we don't know what they're going to be. So it's hard to agree on a price. And this is a very similar thing. Folks are scared of the unknown. And the other thing that we're dealing with is trying to get COs and trying to get people out to do what they're supposed to do. And like I said, it's a case-by-case basis. We're doing the best we can. And we're pushing through this, you know, maybe limping through it, but we're getting the closings and we're getting new deals coming in, and there's certain people, they need to close. I had clients that are living in a hotel with their kids and their dog, and they got to get into their new house. I had a couple who lived in New York City, who we spent the past week convincing the town to do everything they needed to do, and they were working from home sometimes, but we got it done, and they moved in on Saturday, and they were very grateful, but we all had to push for it. All right, let's see. Another one. Summer client is trying to cancel for the month of August and transaction is closed. Do you get a refund? I don't know that the answer, I don't know if we have the answer to that yet. I don't see any basis to cancel something that's happening in August yet. If we get to August and there is a restriction on folks coming to the beach or the beaches are closed, there might be some basis for it. But honestly, if you have a contract and that's that far in the future, it is not deemed to be void. You also have to check to see what the municipality is doing. If the municipality is voiding or prohibiting those type of contracts, that could be a basis for a tenant to claim that they get out. And by the way, you know, some of those addendums that came up, you know, those are to be used for new deals, ongoing deals. The parties don't have to agree if they already have a contract to any addendum, even if it's a good addendum for the agents. So they need to consult with their attorneys, and they might need to change them in some way. But, you know, you should still, you should ask and request that they get signed, but you can't demand that they get signed. You know, these are still subject to an attorney's review and the parties agreeing to the terms. Anything else? Going once, going twice. Well, it's just about 1 o'clock. So that was 1 hour. Now I know how long that the COVID-19 webinar is. So again, we're going to set some more up. Check in with us on our website, and I'm going to do additional podcasts and webinars coming up. So keep an eye out. If you follow me on Facebook, like my Facebook Brad Batchet page, and that way when I post things, you'll get updated information. So everyone, I appreciate you signing in, and hope everyone has a good day and good luck with all of your closings, and get in touch if you need anything. So bye-bye.